Industrial law for your All India Bar examination. This is a quick, rapid revision. Within 10 minutes, we'll complete at least like 10 to 15 questions, which is very important for your All India Bar examination. At least you'll be getting, if without a count, like it's very easy for you to get at least 4 marks just by learning labor law. So why to lose it? Just 10 questions. Don't go through everything in the bar act. At least just go through the 10 questions, which will give you an immunity to answer any questions which is asked in labor law. Okay, starting with the first one. For what duration is a woman entitled to leave with the wages for tuberctomy operation as per the Maternity Benefit Act? That means it's 2 weeks. Okay, so 2 weeks time period is given for you to undergo this tuberctomy operation. Like for example, after doing this operation, like a woman won't be pregnant further. So that 2 weeks leave is basically given. Just remember this. What should be the minimum number of workers originally employed in any factory for having at least one canteen in the factory as per the Factories Act 1948? So minimum number of how many members should be there in a factory to have a canteen? It's 250 members. Remember, it's how many members? 250 members. Who among the following is not included in the definition of workmen as per the Industrial Dispute Act? Who among the following is not included in the definition of workmen as per the Industrial Dispute Act? Very, very, very important. Never forget this. Let's look at the definition. Any supervisor who is getting a salary of rupees 10,000, they are considered as this workmen. All right. So, what is the maximum period for which the woman shall be entitled to get a maternity benefit leave? It's actually 26 weeks. Don't get confused. It's not 36, it's 26 weeks. Okay, 26 weeks. 26 weeks. The minimum number of members required for registering a trade union is basically 7. Do not forget it. It's aram se 7. Do not forget it. Okay. Now, next question is about the test of the certified standing officer shall be prominently posted by the employer in dash and the language understood by the majority of workmen. So if, for example, if there is a certified standing order and it should be in which particular language, in a, like for example, labor setup, it should be in English language. Remember that. Seventh question: a person who has the ultimate control over the affairs of the factory under the Factories Act 1948 is known as the occupier. Okay, remember, a occupier has the ultimate power under this Factories Act. Okay, he's occupier. Remember. Eighth question: if the factory employs more than 1,000 workers, they should appoint qualified dash to carry out the prescribed duties. If the factory employs more than 1,000 workers, they should appoint qualified dash to carry out the prescribed duties. It is a safety officer, welfare officer, development officer, or none of these. The answer is safety officer. This and all you can just remember it. It's very easy for you to remember. The payment of the compensation to railway employees by the railway administration for injury by accident is coming under which particular act? So for example, if any kind of compensation you're providing for the railway employees, if they got some kind of accident or anything like that, then under which particular act will you do? Is it in Payment of Wages Act, Right of with Disabilities Act? Obviously it's not. You can eliminate it. Do the elimination technique. It's not Rights of Person with Disabilities Act, so you can eliminate it. The Workmen Compensation Act, no, it's not workmen compensation. It comes in the Employees Compensation Act. Remember, railway employees, it is always Employees Compensation Act. All right. The railway servant was killed in a bus accident. During the course of employment, his family members may claim compensation under Motor Vehicle Act, Employment Compensation Act, or both A and B. So either under A or B, it is possible. Either in the Motor Vehicle Act or under Employment Compensation Act, you can get the money back. Remember that also. Now, 11th question is about the minimum amount of compensation payable to the Employment Compensation Act 1923 is. So for that, it's very simple. Just go to your barrack. Go to barrack. There's an Employment Compensation Act. I have this edition of this professionals. If you go to this Employment Compensation Act, very clearly, if you observe, what is the compensation aspect or what is the compensation is very clearly been prescribed over here. All that I want you to do is just amount compensation. If you observe, section 4 speaks very clearly, 25, it's 1,40,000. You can clearly get it's not, it's basically in the barrack. Okay, now schedule 2 of the Employment Compensation Act. So schedule 2 of the Employment Compensation Act, again if you observe, schedule 1, schedule 2, open with me the barrack. Okay, Employment Compensation Act 1923, open it right now with me and open schedule 2. For me it's page number 55 in professionals barrack. Let me just show it to you. So I'm doing it along with you so that you are also getting a habit of it. Okay, so if you observe over here, the list of person who is subject to the provision of are included in the definition of this employees. So the schedule 2 of the Employee Compensation Act 1923 deals with what? The list of person who is subject to the provision of are included in the definition of the employee. So it's exactly the same. Ditto heading is over here in the BAR Act itself. So nothing much to learn. It's directly in the BAR Act. Okay. Now, 13th question. A teacher is not a workman with the purview of Industrial Dispute Act. Held in the case of which one? So teacher is not a workman under the Industrial Dispute Act. Under which case did they say this? It was in Sundaramambal versus the government of Goa case. Okay, Sundaramambal versus the government of Goa case. Remember this. Very simple questions. High chances there to repeat. According to the Factories Act, child means person who has not completed his 15 years of age. Remember this, it's very easy one. Under Factories Act, again in your barrack itself you observe, I want you to just get a little more familiarized with your barrack and parallelly look where the concept of child comes. Okay, let me know under which particular section the child comes, and tell me under what particular category will you be doing it. So it's very easy, just I'll tell you one small technique. Okay, under the where is the question? Yes. According to the Factories Act, look at the heading. Is it preliminary or is it the inspection staff, health, safety, provision of relating to hazardous, this one, welfare, working hours of adults, employment of young person. Okay, employment of young person. The prohibition of employment of young person. So there itself some key terms you'll be able to get it. Okay. So just look at the headings, read it once again and again, you'll be able to get this particular answer. The mere illegality of strike does not per se spell unjustified under which particular case? It was in Gujarat Steel Tubes versus the Gujarat Steel Tubes Mazodar Sabha case. A very important case. Just take a screenshot of all the notes which we discussed for today and just go prepare. It'll be very easy for you. The mere illegality of the strikes does not per se spell unjustifiability. Was decided in the case of Gujarat Steel Tubes versus the Gujarat Steel Tubes. See, it's not possible to learn all the case laws, at least important which I'm discussing with you. If you're able to do it, it'll be sufficient enough. So why do you want to lose marks for it? And I just request you to join our WhatsApp group. We'll also be providing you free materials for your upcoming preparation. Make sure that you are utilizing it for your preparation. Okay. Wish you all the best. Good luck. This is me, Pawan signing off. Take care. Goodbye. And you are going to ace this.